This week, 4 very different stories, from AI in San Francisco courtrooms to data breaches on Wall Street to regulators in Nevada, all point to the same reality. Your greatest risk now lives where law, regulation, and reputation intersect. I'm Brian Glicklich with Digital Strategy Ltd. Let's walk through what mattered for boards and C-suites over the past 7 days and what you should be asking your teams before your company becomes the example. In segment 1, AI and IP, training data as a billion-dollar liability. Let's start with artificial intelligence because it's no longer just an innovation headline. It's a litigation and disclosure story. In federal court in San Francisco, lawyers for authors and publishers are asking for hundreds of millions of dollars in fees from a multi-billion-dollar settlement with Anthropic, the company behind the Claude AI system. The core allegation is simple and powerful, that Anthropic trained its models on pirated books without permission and is now paying dearly for it while agreeing to destroy certain training data. Whether you're in tech or not, this should get your attention. From a crisis and strategic communications standpoint, there are 3 key questions. What did we tell the world about how we use data? If your company has ever marketed its AI, analytics, or personalization as responsible, ethical, or privacy first, plaintiffs, lawyers, and regulators are already mentally underlining those words. Do we actually know what's in our models? It's not enough to rely on vendors or legacy documentation. Boards and CEOs should be asking for clear, non-technical explanations of where training data came from, who approved it, and whether licenses and consents actually match your marketing language. And finally, do we have a communications plan if our models are challenged? When a settlement hits, the story isn't complex IP questions, it's company admits using stolen content. That's the narrative you have to be ready to confront in real time. The bottom line, AI isn't just part of your product roadmap anymore. It's now part of your reputation risk register. In segment 2, data and privacy, breaches that just won't go away. This week brought yet another reminder that your vendor's mistakes can become your problem. A financial technology provider disclosed a breach that exposed sensitive information connected to multiple major U.S. banks. Those banks didn't cause the breach, but try explaining that nuance to a customer or a skeptical regulator or a plaintiff's attorney. At the same time, past breaches are still echoing. Telecom and financial institutions are finalizing settlements worth hundreds of millions of dollars with customers eligible for substantial individual payments. A large vision care provider agreed to a multi-million-dollar settlement over a breach that happened years ago, but is only now being fully resolved. And in the market structure world, a major trading firm will pay a penalty because employees shared a single login that allowed broad access to confidential client trading data, directly contradicting what the firm had promised about protecting that information. There's a clear pattern here. A technical lapse becomes a trust problem. The trust problem becomes a regulatory problem. And the regulatory problem becomes a headline that lives on forever. For CEOs and boards, there are a few questions you really have to ask. First, do we have a clear inventory of our highest risk data relationships, especially vendors that touch customer, patient, or client information? Second, are we sure that our public promises about data protection can be backed up with actual controls, not just policies? And finally, when something does go wrong, do legal and communications work from the same playbook in the first hour? These are the things you have to know. Segment 3, Nevada gaming, regulation as a reputational signal. Let's talk about Las Vegas and gaming. Nevada's regulators are not just inspecting slot machines and cage procedures anymore. They keep redrawing the lines around what counts as acceptable wagering and financial innovation. Recent notices and workshops from the Nevada Gaming Control Board and Gaming Commission are focusing on new topics. First, prediction markets and novel betting products, including how they overlap with financial instruments. Second, updates to core operating regulations that will shape compliance expectations for years, and the message that licensees are expected to Anticipate emerging risk, not just react to enforcement. Why does this matter beyond Las Vegas and past the Strip? It's simple. Nevada remains a bellwether for gaming and wagering globally. When regulators here move, other jurisdictions pay attention. And when your company is licensed in Nevada or partners with somebody who is, you inherit parts of their regulatory story. This isn't just a compliance issue, though. It's a strategic communications issue. For example, how do you explain to investors and partners that you're ahead of the curve on new rules, not continually scrambling to catch up? Do your internal town halls and external statements align when it comes to risk, fairness, and consumer protection? And finally, if Nevada's actions are interpreted as a broader crackdown, are you prepared to show how your culture and controls differentiate you from any headline about the industry? These are the things you have to work on now and not be caught behind. Finally, segment 4. Let's go to Washington, the enforcement mood and political narratives. The federal enforcement mood continues to harden. For example, a recent executive order directs the Justice Department and FTC to stand up task forces focused on competition and foreign influence in areas like the food supply chain. Privacy and cybersecurity expectations are tightening, with evolving guidance on how fast and how fully companies must disclose incidents. Agencies are increasingly comfortable turning individual companies into symbols in broader political debates about prices, foreign influence, or consumer harm. For executives and boards, this has important implications. First, your ordinary business decisions can suddenly be framed as matters of national security, consumer protection, or even democracy. Your litigation and regulatory exposures are deeply, deeply intertwined with your public narrative, and you cannot afford to have legal, public affairs, and crisis communications operating on different timelines. So, what should you do this week? I'd suggest 3 questions. If tomorrow's headlines accused you of misusing data or training AI on the wrong content, what would you say in the first 60 minutes? Do you have facts, approvals, and a clear explanation, or just ideas and aspirations? 2, which third parties could put your reputation at risk with a single mistake? Vendors, partners, and platforms all deserve the same scrutiny you'd apply to your own systems. And 3, when regulators in key jurisdictions move, do you treat it as background noise or as a chance to lead in the market? Whether it's Nevada in gaming or Washington on competition and privacy, you want to be seen as anticipating the future, not being dragged into it. I'm Brian Glicklich with Digital Strategy Ltd in Las Vegas, and this is the week of December 7, 2025. If any of these stories made you think, I'm not sure we're ready for that, that's exactly when you should be talking to a crisis partner. Before the subpoena, before the leak, and before the viral post. Thanks for watching. We'll be back next week with the risks that matter before they land on your board table. Have a good week.